Welcome to Bill on Bankruptcy. I'm Edward Adams, sitting in for Lee Pacquiao. We're joined, as always, by Bloomberg News' bankruptcy expert, Bill Rochelle. You can read his daily column on BloombergLaw.com, as well as on the Bloomberg Terminal. Bill, starting off today, we're looking out at California, where there appears to be a split between the Ninth Circuit and the Midwest's Sixth Circuit. Tell us about it.
Well, hugely important. This is one of the unanswered questions from Stern versus Marshall last year from the Supreme Court. The question is, if you don't raise an objection to the power of the bankruptcy judge to make a final decision in certain types of state law claims, can you raise it for the first time on appeal? There was a decision back in October from the Sixth Circuit in Cincinnati which said it's not waivable. You can raise it on appeal. Well, the Ninth Circuit held precisely the opposite. They said it is very much waivable, and here's why this question is so important. If the courts decide it is not waivable, well then what else does that mean? For instance, could you challenge what a bankruptcy court did, perhaps months or years afterward, if it were never ratified in a district court? If it's waivable, if it's not waivable, then it is very possible we could be in a situation down the road where, frankly, bankruptcy judge orders in some kinds of cases are not worth the paper they're written on.
Moving on then to the Judge of the Week. Your pick this week is Frank Easterbrook in Chicago. Tell us why he got the nod.
Well, because he's a fine judge. He, along with his colleague Richard Posner on the Seventh Circuit in Chicago, routinely write the most literary, entertaining opinions on earth. This one, however, is extremely important because what they did was to rule that the decision from the 1980s from the Sixth Circuit in a case called Lubrizol is wrong. Now, they can't overrule another sister circuit, but here's what they said. The case deals with the question of trademarks in bankruptcy. The Lubrizol court held that if a bankrupt company rejects a trademark license, poof, it's gone. The person who thought they could use the mark no longer can. Well, basically, Easterbrook said, phooey, we disagree. What is significant at this point now is that the Supreme Court decided this week not to hear the case. So people out there in the intellectual property business can wrap themselves around Easterbrook's decision and be much happier for it.
And of course, it's the holiday season. Hanukkah is underway. Christmas is around the corner. I understand you have unearthed a bankruptcy court decision involving religion. What's that all about?
Absolutely. Of course, it's not a very happy case. It's the Roman Catholic Archdiocese of Milwaukee. We talk about it because the Archdiocese won a very important decision over the Creditors Committee, which essentially represents victims of sexual abuse. The committee wanted to sue the 210 parishes in Milwaukee to bring all of their assets into the bankruptcy to pay off claims of these abuse claimants. Well, the bankruptcy judge gave him a shot to the head and said, no, you can't. The court not only refused to allow them to bring a suit, said, even if you tried, I'm going to dismiss it because we can't pierce the corporate veil. They're not the alter ego. So you, the claimants, have no right to glom onto the assets of the 210 parishes in Milwaukee. A very important decision by bankruptcy judge Susan Kelly in Milwaukee.
Well, speaking of the holiday season, I'm in the market to buy some distressed companies as stocking stuffers for some of my close friends and family. Any sweet deals out there for me?
Well, I got the first one for you. Is actually sour.
Sour?
How about a pickle plant? Pickle, sauerkraut, cabbage, things of that sort. Yes, sirree, called Pleasant Valley Farms out in Seattle. They thought they had themselves a deal, but it fell apart. Now, that buyer may come back, but in the meantime, if you like the pickle business, what better? Maybe Seattle pickle and coffee together. Oh, by the way, that reminds me, there is a coffee case.
Yeah?
You could have pickles and coffee together. This one is also in Seattle. It's called Tully's Coffee Shop. They have a buyer already who's going to pay about $1.2 million cash. There is somebody else called Barista's Coffee who wants to submit a competing bid, but from what I can see about Barista's financial condition. They barely can rub two dimes together. So if you like the coffee business in Seattle, you could think about buying it. However, frankly, do you remember who else in the coffee business is located in Seattle?
A small little coffee company called Starbucks?
Yeah, I'm not sure I want to compete out there.
Yeah, I don't think so either.
Well, finally, if you're interested in the banking business, I have Capital Bancorp for you. This is in Detroit, has 10 branches. They had a deal that fell apart. So if you are in the mood for buying yourself a bank and being a big, bank officer, that's for you. Go out to Detroit.
Terrific. Let's turn to the advance sheets for this week. What's the major decision on your radar this week?
As always, if there is something that says anything coming out of Delaware, it's a big deal, and that's what we've got. We have a decision by District Judge Leonard Stark upholding the bankruptcy court, again giving a drubbing to the U.S. trustee. The question is, if you have a settlement where a secured creditor gives up some money and says, listen here, I'm giving this exclusively to unsecured creditors, can that be upheld even if it means there were priority claims or expenses of administration that don't get paid? Well, Judge Stark, as I said in Delaware, it's very important, upheld what happened and said, yes, sirree, my goodness, you certainly can simply leap over the rules of priority in the bankruptcy code, make your own priorities, and give that money exclusively to unsecured creditors when priority creditors are not being paid. That is a big deal, as I said, because it's Delaware. If the case one of these days goes to the Court of Appeals in Philadelphia, that will be even more important, but we're not there yet. Meanwhile, you can get away with this sort of stuff in Delaware and probably also in New York.
Well, that's good to know. As always, that's Bill on bankruptcy for this week. Thank you, Mr. Rochelle. We'll be back next week. In the meantime, if you want daily updates from Bill Rochelle on all matters bankruptcy worldwide, check him out on BloombergLaw.com as well as on the Bloomberg Terminal. I'm Edward Adams. Thanks for joining us.